Resuming debate, the honourable member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. Today, I will be speaking to Bill C-293 that will create a category of vexatious complainants under the Correctional Services Complaints Process. This bill amends Section 91 of the Corrections and Conditional Release Act. I'm going to quote from Section 91 that provides for access to the grievance process. Any offender must be able to access the grievance process without fear of reprisal. Under this section, any inmate within the correctional system can have free and full access to the grievance and complaints system if they feel that their health or their safety is under threat in some way. This section did not just happen by chance. The complaints and grievance process was established by a parliamentary subcommittee in the 1970s. During that time, there had been several revolts, riots, and violence that was making prisons dangerous for everyone, whether that be offenders or employees. The complaints and grievance process was a way of giving voice to these individuals without having to use violence in order to express their concerns and to find answers to their problems. Today, a bill would amend this section, a section that gives inmates an opportunity to express themselves and to attempt to find solutions to problems and solutions to their frustrations through other means other than violence. The proposed amendments overall is the following. If the Commissioner is satisfied that an offender has persistently submitted complaints or grievances that are frivolous, vexatious, or not made in good faith, the Commissioner may, in accordance with the prescribed procedures, prohibit an offender from submitting any further complaint or grievance except by leave of the Commissioner. So the general idea is to provide the Commissioner with the possibility of prohibiting certain complainants from making complaints, and that is on their discretion, at their discretion. We're not just talking about any complainants, we're talking about complainants that the Commissioner feels are vexatious. I'd like to come back on the idea of frivolous. The member for Scarborough Centre, who is sponsoring this bill, provided one example that she considers to be frivolous, and that is that of a radio. And I will just talk about the example that she gave in her speech. An inmate tabled a complaint, or rather filed a complaint, because a radio was not working in the new prison that they were in. He then filed another complaint about the same radio, while his first complaint was being assessed by the prison that he had been transferred from. Now, when someone isn't aware of the reality of prisons, perhaps, yes, making a complaint about a radio might seem frivolous. However, there are other aspects to this. First, it's very important to recall that in a prison, in a correctional institution, what may appear to be insignificant or futile or vexatious or frivolous from our point of view may be very important for the inmates. Some things that aren't necessarily important for us may become very important when one is an inmate. And forgetting that difference in perspective is just simplifying things within a debate about grievances and complaints. Furthermore, sometimes these kinds of complaints can hide other frustrations or other problems that inmates are facing and that they can't necessarily articulate, such as conflicts between offenders or long-standing stress, harassment, for example, or depression. So in this case, the radio is simply the straw that broke the camel's back. Taking that example and qualifying it as frivolous or illegitimate is too simplistic, because there may be other problems that this complaint represents. An inmate may have a long-standing problem and may be trying to repeat their complaints that may appear to be illegitimate. However, if there is a prohibition against filing other complaints, then that situation will not be resolved and may become worse. So this is not the right solution. This kind of complaint, for example, in this case, is not necessarily important because it allows to resolve radio problems, but rather because it gives an opportunity to obtain more information on a broader problem within the prisoner, whether that has to do with other inmates, internal tensions, or tensions with the staff. So I think it's important to maintain this perspective. It's important to keep communication open between administration and offenders. In the annual report from the Correctional and Investigators Office in 2010-2011, it states that the grievance process for offenders is an important tool in order to be able to assess the conditions of the inmate population. It also should be pointed out that 48% of complaints often are the subject of a long turnaround time. The turnaround time for complaints varies according to their classification. According to an internal audit of the grievance process and inmates' grievances published by Correctional Services Canada in 2009, 67% of priority complaints were only classified as such, and only 13% of urgent cases were classified as being urgent. Only 64% of the complaints that had to do with harassment were correctly classified. Filing one complaint or filing successive complaints on the same subject is sometimes an attempt to draw attention to a more urgent problem, a problem that is more urgent than it appears to be, or it may be because a complaint was not classified properly. So what I'm trying to do is point out that repeated complaints or complaints that may seem frivolous, as given by the member of Scarborough Centre, may not be relevant in the eyes of all, but sometimes they are when you look at it from a different perspective. The member for Scarborough Centre says that the number of complaints is fairly high for the correctional system, and this is a problem that has to be resolved. I agree. However, she's also said that the overload of grievances comes from a small number of inmates who think that it's simply fun to file frivolous complaints, and so she thinks that by prohibiting complaints, the problem will be resolved. I'd just like to raise a few examples pulled from the annual report of the Correctional Investigator 2010-2011. CSC has noted that there has been a significant increase in the number of complaints and grievances in 5 main categories. There are certain subjects that come back several times and that have been priorities as identified by the correctional investigator in his reports over the past few years. Generally, there have been harsher prison conditions. There has been a deterioration of security and interactions between staff and offenders. There's been an uneven quality and uneven access to mental health services. There's been a problem with access to programs, and there have been restrictions on privileges. From what I understand in this report, there has been an increase in complaints in the prison system, and this is not because of frivolous complaints. The increase in complaints is rather a reflection of the inability of past governments to take into account and to tackle the true priorities in prisons. The NDP members sitting on the Standing Committee of Public Safety when the bill was considered stated that they supported creating mediation positions and grievance coordinator positions in correctional centres, but that was not considered to be a relevant suggestion on the part of the Conservatives. I'd like to talk about a few more things that were mentioned within the Correctional Investigators report. In prisons that use a mediator, a higher percentage of complaints and grievances appear to be resolved at lower levels. In prisons where there is a grievance coordinator and where there was a grievance coordinator for more than 1 year, complaints and grievances appear to have been resolved in a more efficient way. Administrators who feel that complaints and grievances are important appear to be able to resolve more problems for their inmates through complaints and grievances processes. So I would say to the member for Scarborough Centre that she should read this report. And I would like to wrap up by saying that I will not be able to support this bill because I feel that it is a bill that will bring about more violence in our prison population, and it doesn't tackle the problems that are at the heart of these complaints. Thank you, Mr. Speaker.